Hello, I'm April Jones, and we at Jones Law Firm care about you, your family, and your well-being. That's why we've put together this informative webinar series to answer your questions about life, about the law, about your family. So thank you for joining us, and let's get started. April Jones here, Jones Law Firm PC, and I am with some of my amazing team. Sarah Kroll, Adele Luan, and William Garvey. So we are really excited to be here today. And we are going to talk to you about getting through divorce during the holidays. So you're thinking about it, it's been mentioned to you, it's on your mind, you're trying to decide what do you do next. That's what we are here to talk about today. Jones Law Firm PC, we've been serving Colorado since 2000. We do family law exclusively. So we answer these questions all the time. And so that's why we're here. We're here to help you because you don't do this all day, every day. And it is rough and it can be really challenging during holidays because you've got to decide how do you, what do you say to your family? What do you say to your friends? What do you think in your head? How can you possibly be happy? Just all sorts of things. Like we've seen some version of it all. I've been a lawyer over 30 years, and we're here to help you. So we're here to use our collective knowledge to answer questions. And why don't we start with having the team introduce themselves and say why they are in family law? Like, what is it about them and family law and you that would make a difference? And we can start with Sarah.
Great. Hi, my name is Sarah Kroll. I've been practicing family law for 8 years. I'm passionate about family law because I really enjoy helping families and making sure your kids are safe and happy. Divorce is really difficult, but it doesn't have to tear your family apart. And I just want to help you and your family move on and become happier even after this process.
Thank you, Will.
Hi, my name is Will Garvey. I'm actually new to practicing family law. I am a fourth, soon to be fifth year attorney. I previously worked in civil litigation representing hospitals and doctors. The reason I got into family law is because I want to actually see the people who I'm helping. So often in my previous work, I would be representing a hospital without a face, without really a client to really be working for. So it really wasn't all that fulfilling of work for me. Family law has really allowed this to be a fulfilling practice for my life while allowing me to stay in the courtroom. I get to really see the impact I have on the families that I'm able to represent and help through these difficult proceedings.
Thanks, Will. Will's a great litigator, so we are excited to have him. Adele, another
Hi,
great
my name is
litigator.
Adele Ewan, and I've been an attorney for a little over 5 years now. I like working in family law because I like making an impact. I also like being in the courtroom, but just having that interaction too with, the client as well as with opposing parties, opposing counsels. I just really like helping people out, and I think this is one of the best areas of law and to do that.
Thank you. Okay, well, here we are. Let's go ahead and get started. And we've got questions. And thank you. So the audience is not visible on the screen. But we have your questions and we're just happy to talk to you. If you have more questions that you want to put in the chat, please do. Okay, so one of the questions we have is what's the difference between separation and divorce? That is a common question. And who wants to answer? Sarah, do you want to answer the difference between separation and divorce?
Sure, yeah, absolutely. So separation is really an opportunity for you and your spouse to separate your financial assets while still retaining things like insurance. You can still remain on one another's health insurance. If you need access to different benefits with your employer, that can be a way that you can go ahead and separate bank accounts, figure out what your parenting time is going to be while still getting some of the benefits that you would have by filing your taxes together and getting those benefits from your work. Other than that, there isn't a whole lot of differences between separation and divorce in Colorado. It's really just what works best for you and your family to move forward. At any time, if you start with a separation, you can move it to a divorce, and go forward with the case as a normal divorce.
Yeah, that's absolutely right. In terms of the practical filing of it, there's actually no difference between a divorce and a separation petition. Except you say your petition is for separation instead of a petition for dissolution. The process is the same. And a lot of people think that by filing for divorce or filing for, they think that separation is something that you can, oh, we're separated, so now we are. That's not how you get legally separated in Colorado. It's actually a full process, same as a divorce, except in the beginning, your petition for a separation, and in the very end, after your money and your property and your house and your children and your couches and your pets are divided, the court pronounces you legally separated instead of divorced. Those are the bookend differences. And then you remain married, but it's like you've gutted the marriage. You've divided, you've already, instead of it being like, oh, money is everybody's money, or all the, everything is already divided up, but you are still married. So yes, as Sarah was saying, that allows you to be on health insurance. It allows you to still be married. You can't marry anyone else because you are married. In order to not be married, though, that's where it gets a little extra step, is there's a waiting period. So you have to wait over 180 days before you can ask the court to change the legal separation to a divorce. So you can change it, like Sarah said, anytime during the process before the court pronounces you one or the other, you can change it. But once it's done, you have to basically wait 6 months, and then you can file it's a paper filing with the court where you ask to have the dissolution instead of the separation as an order of the court. So that's our long answer, but it's a very common question and it's commonly misunderstood. So we just wanted to make sure we were clear in our answer. All right.
Yeah, if I could add on here, Sarah covered that really well. So did April. Sarah mentioned one of the main reasons for a separation over a divorce is to stay on your spouse's insurance. Some other reasons that we often see are religious reasons. There are certain religions that don't allow divorces. So this allows you to separate, get the assets separated, divide the time up with the children as well, while still remaining married and still, participating in your religion and not breaching any of the tenets that might be enacted there.
Yeah, that's a very good point to add. Well, additionally, another reason people can separate is, let's say you don't want to be divorced and you don't even really want to be separated, but your ex has a gambling problem and you don't want to be tied to their debt. And they've made promises for how they're going to change. And fill in the blank, your ex has a fill in the blank problem. But you want to give the marriage a chance, but you don't want to continue to expose yourself to whatever the problem is. Let's say gambling debts that can destroy the marital estate. So you can divide the marital estate. You can separate the children, protect them from the person who's abusing fill in the blank, but then you can continue to work on your marriage because you are still married. So a lot of people use it to create protections that they need for themselves or for their children, while at the same time trying to give the spouse an opportunity to make the changes that they've promised, to clean up their act, to be the spouse that they say they want to be. So it gives people probably not second chances, probably 10th chances, it gives people chances too. So a lot of different, these are just a few reasons that people file for separation. Some people say, why would anyone ever file to be separated? And I say, a lot of reasons. It's very personalized. And what we believe in at Jones Law Firm is we believe in a personalized approach. So what Sarah might say to you when she talks to you at noon could be completely different than what she says to someone on the same facts when she talks to them at 2 p.m. because their objectives are different. It's so important to us that we find out What is your wish list? What is your objective? If this could go any way you want it, what do you want? And then from that answer, we start to craft and strategize what's the best solution for you. Anybody want to add anything else? All right, let's move to, does it matter who files for divorce first in Colorado? Nope. Anybody want to add anything else? You're either the petitioner or the respondent. The petitioner can, go first in a trial. The petitioner goes first if it's just the divorce hearing, and then the respondent goes second. But in terms of the court saying, oh, you're the one who asked for it, does not matter at all. Anybody want to add anything, or litigators want to add anything?
One thing to add would just be, you can also be a petitioner and a co-petitioner. So you can file together. So say it's a more amicable divorce or legal separation, and you have both talked about it and you both agree that you're going to file for divorce. You can file as petitioner and co-petitioner. But again, it really does not make much of a difference if you are a petitioner or respondent.
And one other difference is there's a little bit of a difference in the filing fee. The petitioner, when they file the petition for divorce, that's a $230 filing fee, and then the response is $116. So the respondent might be paying a little less in filing fees.
Good point. And sometimes the petitioner is the one who drafts the document first. Let's say a joint trial management certificate. It could be that the petitioner drafts it first and then hands it to the respondent, and the respondent works on it. So it's that sort of thing. Procedurally, there are some who goes first, who goes second, but it doesn't matter to the judge, but it does matter if you're asking about these little ways.
And I think it's important to add that being a petitioner or a respondent doesn't give you an advantage in one of these cases. So don't be worried if your spouse files first and you feel that, oh, you're on the defensive now in the response position. There's no advantage to that. The court's going to give you adequate time to put on your case, present all the facts as you see them as well.
Now, again, thank you all. In terms of doing what's best for you in your case, we can talk to you and deciding your facts. It's better for you to be the petitioner or the respondent. Let's say that you have someone who you can work with and you think you can reach a settlement outside of court, and we can get you more than maybe what the judge would do, but they would be so, insulted if you filed first. So we'll let them file first, and then you'll be the responding party, and then we'll go out and try to settle your case. So there are reasons to be strategic and thoughtful, and there are many. I was just giving you that small example about when it can come into play, and you sit down with us, we talk about it. It could not matter at all to you, or it could matter. Or you could be a nervous Nilly and you don't want to go first as the petitioner. You want to just wait and hear everything as the respondent. That's a reason. So lots of minutia that we look at when we're trying to give you personalized legal representation. Okay, next up, what does it mean for Colorado to be a no-fault state? With sub-questions that we combine, what if my spouse cheated? What if my spouse wants a divorce, but I don't? How does all that play into a no-fault state? Who wants to take this one? Sarah?
Yeah, I definitely can. So for Colorado being a no-fault state, for good or not, the court doesn't really care too much if your spouse cheated, or if they did something that you think they should be held responsible for or held accountable for. The court doesn't care why you're divorced. All they care is that whether the divorce is irretrievably broken. And if that's the case, you can move forward with a divorce. You don't need to provide reasons to why you're getting a divorce. It can harm your case in some ways to focus too much on why you're getting a divorce and why you believe that those actions of the other party should affect how your finances are divided, or how much time they have with the kids. So it is really important to be careful with allegations that are brought up during the divorce process.
Now, that's a very good point. Sarah, there are times, so the court does not care that you had an affair. So that's the answer to the question. They don't care that the other side had an affair. It's a no fault state. You bring that up for no reason, it can irritate the court. But if you bring it up for a reason that ties into some other area of the law that matters, then it can come in. So for example, a spouse cheats with a guy who sells drugs, smokes weed all around the baby, and maybe posted on Facebook about it and said, I'm so high, I can't get off of this couch. Say suppose. And that is the spouse. Well, now, or that's the person you're cheating with. Now it's relevant that you're cheating with this guy. Now I can enter that photo in, or someone else can, because it's relevant, because we're saying this person isn't safe around your child. So if it comes in for a proper purpose, then it can come in. It doesn't come in as to why you get a divorce. It doesn't come in as to how you can punish your spouse for alimony. However, if a person depletes marital property for a non-marital purpose, that's a reason it can come in. If it turns out this guy you've been spending all your money on the guy or the woman, and you've been, buying motorcycles and motorcycle jackets and traveling the world, and there's all sorts of things people do, then it can come in how they are, it can come in because now they're spending money on this person that's not for a non-marital purpose and is hurting you financially, which comes in under the statute. So again, it's about being thoughtful and strategic. Like, how does this play into your case? Does it come in? Is there a reason it does, or is there a reason it doesn't? And that is how you treat no fault. It just depends if there's something that it goes to. Anybody else want to add anything? Because otherwise, is even in the end, they ask you, when you're getting divorced, you have to, one of the things you state is there are irreconcilable differences. And the court will say, are there irreconcilable differences? Yes, that is what is required, that statement. Will.
Yeah, so to kind of piggyback on what April was saying, sorry. So it's important for us to know this information so that we can be strategic with this. During any consultation we have with you, we can try to figure out how that information may be admissible to the court and how we could use that in the case. So it's always important to bring that up to us. It's something you can bring up during initial strategy sessions with us. We have free consultations as well. That it's also very useful to bring up during those, because that will help pair you with an attorney who may have more experience in cases where there have been these type of allegations thrown around.
Yes, thank you. Okay. Is physical abuse considered a part of the court being no fault in their decision? Physical abuse is different. Go ahead. Who wants to answer that question? Sarah?
Yeah, one way that I'll say it's different is with if there's kids involved in the marriage. The statute specifically states that if there is domestic violence, and for instance, you're having to flee the home for domestic violence, that can't be used against you when figuring out parenting time for the kids. And if you're having to remove the kids from that situation, the court's also going to want to consider that. There's a new statute that's been passed this year that requires the court to consider whether there was domestic violence in the home when determining the parenting time between you and your spouse. So it does affect parenting time in particular. It does affect how finances are divided, especially if there's been financial abuse. So that is a consideration that's a little different than any other potential fault that would be brought up in a divorce process.
And a lot of it comes up in terms of how you interact, and if even with children, it comes up a lot that the violence was between the spouses, but not towards the children. And the court can really, you can parse that out and say, well, the children are fine and safe. And what the court does with that and how your facts play out is case dependent, but all of that will come in. They could say, for example, the stress between the couple will be alleviated because they'll no longer be living together. They'll exchange the children at school in a way that they never see the children, and so it won't affect the child. It depends. Sometimes that argument is horrible, and sometimes that argument is perfect for the situation. But it really actually depends. And if people use domestic violence to control finances and to manipulate, the court can look at that when there are no children.
I think adding on to that as well, if you are a victim of domestic violence, there's a few other protections that you can have throughout a case, or you can even seek a permanent protection order from the other party. And, I think when you are a victim of domestic violence, it's also really helpful to have an attorney, because they can be your advocate and communicate with the other side, with your ex or their attorney. And that really takes a lot of the stress off of you, if you don't have to communicate with your ex directly, especially if there is some kind of protection order, either in a criminal case or a permanent protection order that you apply for yourself due to domestic violence.
That's an excellent point. So to the question about what if there's no children, we can get you protection orders, and you get a temporary protection order. You can have the spouse out of the house. You can have the spouse ordered to continue to maintain the financial responsibilities that they had been maintaining during the marriage. And it can help you, get settled in a lot of different ways depending on your circumstances. And that's something you should definitely talk to one of us about, talk to your lawyer about, because that is a tool to protect you, but it also can affect how things play out in the dissolution. For example, let's say you get temporary custody of the house and you have it for a year, and now it comes time to divide the house and you both want it. Well, you've been there, right? Now you've been there alone for a year, and the other person had to move out and find a place to live anyway. Or maybe they moved out and they moved someplace far away and they aren't able to see the children regularly because they just went and they're on their brother-in-law's couch, and it's in 2 hours away from where the school is, and they don't see the kids. Like, there's just a lot of ways this can play out to your advantage or against you, just depending on your past. But definitely, if you've got a domestic violence situation, there's resources for how to protect yourself and protect your family. And we can get you those. You can look those up. You can talk to us about it. So very good point, Adele. Thank you. Is 6 to 9, here's a question. Is 6 to 9 months the norm for divorce in Colorado? What is the norm for divorce in Colorado? What is the norm for pricing for a divorce in Colorado? Well,
So-
go ahead,
Oh.
Will.
All right, so I can speak to that. I'll give you the answer that all attorneys kind of laugh and joke about. It depends. It really was going to depend. It's very fact specific, and how agreeable you are going to be throughout the divorce process. There's a minimum amount of time, which is 91 days. That's the quickest you can get divorced in Colorado, and if you've got some sort of agreement, you can get through that quickly. Even with a court hearing, you could potentially get through it in 91 days. You may have been able to a couple of years ago. Today, a little different. The courts are all backed up. They're a bit understaffed. So things do take a little longer than they have in the past. We're always trying to get everything moving forward. So, get out there and campaign for the judges. We need more of them out there in the courts. But so it really can take, as short as 91 days, but it could even take a couple of years. Unfortunately, that is the reality sometimes, and that it really depends on how contentious the cases are. The cost for that is really going to depend on how long the cases take, how much information is going back and forth between parties. There are mandatory disclosures where you have to give up financial information. But if there's discovery that then has to go into that, that's, something else that's going to increase costs. It's not unheard of for cases to cost $15,000 to $20,000, but it could go up even higher than that. It really just depends on how the parties get along and how everything's kind of moving.
Yes, that is exactly right. I imagine, so to the extent that the cases are by the hour, if you have someone who's always filing motions and we've got to respond, If we have somebody who's, protection orders and contempt, somebody failed to comply with a court order, how much tussling are you doing? How much tussling are we having to do for you? That is where you get a lot of costs. Now, if you get a couple folks and you reach an agreement on everything, we draft it up, like Will was saying, we could file it before the 90 days. We can exchange financials peacefully. We can agree on how you're going to divide things, file it all with the courts, try to set a date for, after the 91st day for the court to rule on it. And that could be that. So it could be as easy as that, or it could be more complicated. You could have a trial in a year, and we've had judges not issue orders for months and months. Not the ideal, not the goal, but it does happen. And you're asking what the range is. So that's what it is. It depends. Are you going to go to trial, or are you going to be able to settle and go to mediation? That, just different costs. And are you going to mediate for a day or several days or just a half a day? A lot of that is in your control potentially, right? And once we sit down and talk to you and we get an idea of the players and who's feisty, and who's not. I had a vet call my cat spicy. So it goes, she's a little spicy today because she didn't want her nails clipped. So that's where I got that word from. She's spicy. But if you have that situation, we can talk about it and we can say, oh, in this situation, you'll probably have to go to court this many times, or we might have to be this responsive, and we see the range of X for you.
I think experts are another area where you might run into some more costs. So say you own, you and your spouse own, or there might be separate ownerships as well, but you have several properties and they're located in different states as well as Colorado. Or if you have a really contentious case involving the children, there might be what we call a CFI, or a child and family investigator, who is appointed, and that's going to increase the costs as well as increasing the amount of time that a case might go on for. But experts can also be really beneficial. So getting an appraiser when you have real estate involved, those reports are super thorough and really helpful, as opposed to just looking it up on Zillow, which uses an algorithm and doesn't really know anything about the state of your property.
In the thousands, tens of thousands of dollars that would most likely be on the table if you get an appraiser matters. So saving $600 to lose $10,000, it usually isn't what you want to do. Okay, thank you for that. Let's see what other questions we have here. Is there a way to keep money and property separate when married, or to start making it separate before starting divorce proceedings? So here's the thing. When you get married, if you don't have a marital agreement, historically called prenuptials, if you don't have a premarital agreement or a proper postmarital agreement that says that we are going to treat our money differently than how the court treats it. Instead of money being marital, we are going to say that all money I earn is separate and all money you earn is separate, or whatever, rules you put into your marital agreement. If you don't have those, then the Colorado statute applies and marital property will be marital property. The definition of separate property, so all property acquired prior to marriage that you kept separate will continue to be your separate property, or property acquired during marriage that is separate by inheritance or gift. Or so if you inherit money during the marriage or inherit property, that's separate. If you have property prior to marriage, that's separate. Now the distinction for both of those is, even though your property stays separate, it stays just yours, the increase in value is marital. So if you inherit a house, and when you inherit it, it's worth $500,000, and then when you get divorced 5 years later, it's worth $1 million. That $500,000 is marital property. So the increase in value is marital. So back to your question, what can you do? You would need to have a proper legal pre or post nuptial agreement that you're drafted to have the correct information, the correct disclosures. Is a technical statute that has things that must be in it in order for the court to decide to uphold it at the time of dissolution. So that would be how you would keep your separate property separate. Or if you actually have separate property that you were commingling, you can stop commingling it during the marriage. You can say, oh, the money that I get every month from my trust or from my ex-husband's pension, I am going to put in a separate account in just my name so that it continues to remain separate. So there are those sorts of options, and we could talk about it. And if your case is more nuanced than that, we love nuances. Anybody want to add anything?
Yeah, we've got some great attorneys at this firm who deal with prenuptial and postnuptial agreements. So if you ever need any help with that, feel free to reach out to us. We got a free consultation to let you know if we can help you out there. Then we can get you in connection with some of the attorneys that do that. And something additional on top of that, through a divorce, you can always agree on which property goes to who. Then again, that is something that you will have to agree on. It's something you'll negotiate between the parties. It's always easiest if everyone's getting along well. But that might not always be the case, but that is also another option.
And I think we have time for one more question. Can a spouse force you to sell your home if you do not want to move, but the spouse has already left the home? So I am going to assume some facts for this question. If you have not filed for divorce, it's different than if you have filed for divorce. If you haven't filed for divorce, it's just like any other day. I mean, how does your spouse force you to do anything? But if you have, that's when the court comes in, and it's the court's job to divide money, to divide your property for the purposes of dissolution. Sarah.
Yeah, so there's different situations. Of course, every situation is different, but there's some things you'll also need to consider. At the end of the divorce, something's going to have to happen with the house. So the courts could potentially make you sell the house if there's not an agreement. But before the divorce has even been filed, you have an equal right to that house. You have an equal right to be in that house. They can't force you to leave the home at that point.
Assuming, right? We're assuming that you have equal rights to be there. But definitely post-divorce, I mean, once you file for divorce or legal separation, there's like 3 things that can happen with your house. Generally speaking, I'm sure there are exceptions, but you keep the house and pay the other person out. They keep the house and pay you out, or you sell it. Those are generally the 3 things that are before the court to decide. Now, are they going to say, okay, you guys both live in this house together and we never sell it? You'd have to ask the court to let you do that and say, this is what we want to do, and do that by agreement or something like that. But just generally speaking, recognizing there's exceptions to everything. Who keeps it? Who buys the other person out? Or do you just both sell it? Yeah. Okay, that is all the questions we have time for. Thank you so much to our participants for all your questions, and just for checking us out, and hoping that we can just help you over the holidays and to get through some of this. So we're denverdivorceattorneys.com, and reach out. Thank you to all who attended. Reach out if you need help. Thank you, team. Appreciate you. Thank you for joining us for this webinar. If you or someone you know would benefit from watching a recording of this webinar or any of our other webinars, they can be found at denverdivorceattorneys.com. Thank you, and keep a lookout for future live webinars, and I hope to see you again.